Good afternoon, everyone. I am Mary Krogan, Provost and Executive Vice Chancellor here at the University of California, Davis. It's my pleasure to welcome you to the first event in the 2020-21 season of the UC Davis Forums on the Public University and the Social Good. Today's event is a first in a couple of other ways too. This is the first wholly virtual forum for this series. We are grateful to have this safe option for beginning our season, though we do look forward to resuming on-campus events, perhaps in tandem with streaming, in 2021. This gathering also marks the first forum since I became provost in July, so it is an especially exciting experience for me. The UC Davis Forums was established in 2012 and presents about a half dozen lectures each academic year by experts from a range of disciplines. The series is unique in its purpose. It seeks to promote informed and thoughtful dialogue among members of the campus community and the public on the following subjects: the major challenges facing the public university, ways of responding to those challenges, and how the public university is evolving, with an ultimate goal of helping to produce a public university that will best serve society and individuals. This series poses the following question: what should and can the public university be in the 21st century? In our preceding 8 seasons, the UC Davis Forums has presented distinguished speakers on a wide range of topics pertaining to the public university and the social good. These have included educational access and affordability, diminishing public confidence in and funding for public institutions, the economic impact of UC campuses on their regions, sexism and racism in the academy, and the relationship between academic mission and neoliberal metrics of success, among many other topics. Our next forum, to be held on Thursday, November 12th, will feature Kieran Flaherty, Associate Vice President and Director of UC State Governmental Relations in the UC Office of the President. Kieran's topic will be UC Challenges and Opportunities, Navigating California's Current and Future Political Landscape. I invite all of you to visit the series website, forums.ucdavis.edu, to find information about this season's events, as well as videos of our past events. This afternoon, we are delighted to welcome Walter Echohawk, Native American author, attorney, and tribal leader, and current president of the Pawnee Nation Business Council. The title of his talk is the UN Declaration on the Rights of Indigenous Peoples, Nagpra and Higher Education. This topic is a timely one for a number of reasons, most of all because true justice and inclusion for Native Americans has been delayed indefensibly for far too long. We are grateful for this opportunity to highlight Native American perspectives as they relate to the University of California and higher education in general. Before Mr. Echohawk is formally introduced, I have a few thank yous and announcements. First, I would like to thank all who have made this event possible. The UC Davis Forum Steering Committee, led by Martin Kenny, Professor of Community and Regional Development in Human Ecology. Next, the co-sponsors that have joined the Provost Office to make this forum possible: the Yochu-Dihi Wintun Nation, along with the following UC Davis entities: the Department of Native American Studies, the Aoki Center for Critical Race and Nation Studies, Human Rights Studies, the Hemispheric Institute on the Americas, our Office of Diversity, Equity, and Inclusion, and the Department of Human Ecology. Finally, and most importantly, thank you, Mr. Echohawk, for joining us today to share your knowledge, views, and passion for justice. And one more announcement: today's lecture will be followed by a Q&A period and an honor song. I know we are all looking forward to the entire program. Thank you, everyone, for being here.
Hello, everyone. My name is Inés Hernandez Avila, and I'm a senior faculty in Native American Studies. I'm Nez Perce and Tejana. I will be the MC today. We're happy to have Mr. Albert Titman offer a blessing for this event. Mr. Titman is Nisenan, Miwok, and Maidu. He holds a position at Sacramento Native American Health Center, where he serves as a California State Board Certified Alcohol and Drug Abuse Counselor. And we're really, really happy to have you here with us today.
Wajuksa Kuchi Kalapami Wuya, Akani Asa Albert Titman, Tumale, Nisanen Miwak, Maidu, and the Pit River Nation. Assuming de Miwu. My name is Albert Titman. My tribal heritage is Nisanen Miwak Maidu and Pit River Nation. And my mother is actually descended from what they call Mexico today. And on my father's side, we're Bear Clan people. It's a great honor that I have been asked to offer an opening blessing for our honored elder, Mr. Echo Hawk. And I want to acknowledge the Wintun people whose land the campus of UC Davis exists. And we want to acknowledge the original inhabitants and stewards of the land. And so it's my great honor that I will open up with a blessing, and I will speak in Miwok language, and I want to offer a song. And the song really invites the ancestors of the land to come and be with us as we honor and the words, the knowledge, the wisdom of our honored elder today. Yopna ke yopna do do yopna 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 Jotsa wana ha yopna do yopna Yopna ke yopna do Yopna ke yopna do do Yopna ke yopna do do Wana ha yopna do do yopna Yopna ke yopna ika Jocelyn Koniska Tewale Deke Kamo Huke Gaku Susapu Jujima Aleata Sawana Wekuke Wunga Nixika. And I just offer gratitude to the creator of this great earth and to Mother Earth herself, to the ancestors of the land for giving us this opportunity to breathe the air today, to clean ourselves with the water. We honor our water spirits, to acknowledge our plant and animal relatives, for they sacrifice their life so we can have life. They provide nourishment and medicine and our spiritual tools. And we offer gratitude to our human relatives that join us here today in honoring our honored elder, Mr. Walter Echo Hawk, as we come in a very humble way and in a grateful way today. Oh, thank you. Wile Mutakmo, which is my heart to your heart. Oh.
Thank you, Mr. Titman, very much. I also, before I introduce Mr. Echo Hawk, President Echo Hawk, I want to acknowledge the land acknowledgement statement that is a formal statement from UC Davis. For thousands of years, this land has been the home of Patwin people. Today, there are 3 federally recognized Patwin tribes: Cachildehe, Band of Wintun Indians of the Calusa Indian Community, Quetzaldehe Wintun Nation, and the Yochadihi Wintun Nation. The Patwin people have remained committed to the stewardship of this land over many centuries. It has been cherished and protected as elders have instructed the young through generations. We are honored and grateful to be here today on their traditional lands. On behalf of all the entities who worked so hard to make this event happen, and on behalf of Native American Studies, I want to begin by saying how delighted we are to have Mr. Echo Hawk, President Walter Echo Hawk, as the first Native American speaker for the UC Davis Forums. I'm honored to be the one to introduce him. Walter Echo Hawk was president of the Pawnee Nation Business Council, a distinguished author, attorney, and legal scholar. He was the Dan and Maggie Inouye Distinguished Chair on Democratic Ideals at the University of Hawaii in 2018. He is the author of Battlefields and Burial Grounds, 1994, In the Courts of the Conqueror, 2010, In the Light of Justice, The Rise of Human Rights in Native America and the UN Declaration on the Rights of Indigenous People, 2013, and The Sea of Grass in 2018, a novel. And he's also a wonderful visual artist as well. He practices law in Oklahoma, and in addition to his tribal government duties, he is chair, board of directors, Association of Tribal Archives, Libraries, and Museums, and a Knowledge Givers Advisory Board member for the First American Museum, Oklahoma City, Oklahoma. As a staff attorney of the Native American Rights Fund from 1973 to 2009, he represented Indian tribes, Alaska Natives, and Native Hawaiians on significant legal issues in the modern era of federal Indian law during the rise of modern Indian nations and tribal sovereignty movement. He litigated indigenous rights pertaining to religious freedom, prisoner rights, water rights, treaty rights, and reburial repatriation rights. Mr. Echo Hawk is admitted to practice law before the U.S. Supreme Court, the Colorado Supreme Court, the Oklahoma Supreme Court, the Court of Appeals for the 8th, 9th, 10th, and District of Columbia circuits, Federal Claims Court, and several U.S. district courts. Highlights from his career include, from 1986 to 1990, he represented tribal clients to obtain repatriation legislation, such as precedent-setting legislation in Nebraska in 1989 and Kansas in 1988, directing museums to return and rebury dead bodies and grave objects to tribes of origin. The 1989 burial agreement with the Smithsonian Institution enacted into the National Museum of the American Indian Act, and the 1986 to 1990 legislative campaign culminating in the passage of the Native American Grave Protection and Repatriation Act, Nagpra. From 1990 to 1994, he represented the Native American Church of North America to obtain passage of the American Indian Freedom of Religion Act amendments of 1994. In 2010, he represented the Klamath tribes in a trial to quantify treaty-protected Indian water rights for hunting, fishing, and gathering purposes, and various Tlingit tribes to repatriate sacred objects and cultural patrimony. In private practice from 2009 to 2020, he has represented various Oklahoma tribes, served as a justice on the Supreme Courts of the Pawnee Nation and the Kickapoo Nation, he's taught federal Indian law at law schools of Tulsa University, Lewis and Clark, and University of Hawaii. He's received many honors. He's in the Circle of Honor for Tulsa Public Libraries, 2020. He had the Dan and Maggie Inouye Distinguished Chair in Democratic Ideals position at University of Hawaii Law School in 2018. He won the Lawrence Baca Lifetime Achievement Award in 2015, which is the highest honor accorded by the Federal Bar Association's Indian Law Section. There's a Walter Echo Hawk Distinguished Visiting Scholar at Lewis and Clark Law School in 2015, and he received a Governor's Commendation in 2010 for professional contributions on behalf of Indigenous cultures throughout the nation. He received the Judge Sarah Hughes Civil Liberties Award in 2009 from the Federal Bar Association for Civil Liberties work, and the Distinguished Native American Alumni in 2020 2009 from Oklahoma State University. His awards he's replete with awards, and we're delighted again to have him here with us. And so, Walter, I will turn it over to you.
Thank you, Professor, and good afternoon, everyone. Wow, I can't wait to meet him. That was a wonderful introduction, and I thank you, Professor Hernandez Avila, for your very kind words. I appreciate that. I'm also want to thank the Provost for her great words, as well as the wonderful prayer and the song rendered by Mr. Tipman. And I'd like to join the sponsors of this event as well, the Provost in thanking all of the sponsors, each and every one of them. And of course, thank you to each of you for tuning in to this Zoom webinar. I have to say at the outset, I'm very, very honored to be here to broadcast my remarks to you from the great state of Oklahoma. It's certainly my privilege to be a part of this distinguished gathering that we have here, and hosted by the wonderful UC Davis, one of our nation's leading universities. And it's certainly a big honor on my part to be a part of this UC Davis lecture series. We're gathered today to consider indigenous issues pertaining to the public university and the social good. And the question I will pose in my talk is, how can universities address the public good when it comes to the indigenous peoples in our nation? And by indigenous peoples, I'm referring to Native Americans, that is American Indians, Alaska Natives, and Native Hawaiians. They are, by and large, the most vulnerable, the most overlooked, and the most misunderstood segment in our society. My topic this afternoon, as the Provost mentioned, is the UN Declaration on the Rights of Indigenous Peoples, Nagpra, which is the Native American Graves Protection and Repatriation Act, and higher education. These topics will focus on human rights. And as the Provost mentioned, human rights for Native Americans is a very timely topic in our country today, because the social good for indigenous peoples in the United States is now coming into much better focus in the post-colonial world of the 21st century. And indeed, some legal scholars consider this moment to be a rare historical time for indigenous peoples in the United States, because now today our nation stands at the brink of a brand new era for defining its relationship between our nation and its indigenous peoples, the human rights era. And this human rights era was ushered in by the landmark UN Declaration on the Rights of Indigenous Peoples that was enacted by the United Nations in the year 2007 and endorsed by the United States in 2010. And now, 10 years later, today, on the 10th anniversary of the endorsement of this declaration, we have a national movement, a social justice law reform movement is now underway in the United States to implement this UN declaration and its human rights provisions into the law and policy of the United States. So what is this human rights era all about? Why do we need human rights for indigenous peoples in the United States? And what's the role of the public university in this effort? What I want to do in my talk this afternoon is to cover 4 areas with you regarding these questions. First of all, I'd like to begin by reviewing the human right contents of the UN Declaration. This declaration is a very comprehensive, standalone legal framework that, if fully implemented by all of the nations around the world, and 150 of those nations have endorsed this UN, it holds the promise of literally changing the world. So even though some people already know about the contents of the declaration, by and large, it's an unheralded international legal development. So I want to explain the contents and this framework. Secondly, I'd like to explain the need for implementing the Declaration's human rights standards into U.S. law and policy. Third, I want to explore briefly a California human rights case study about how this declaration can and should inform compliance with the repatriation laws by California colleges. And then finally, I'd like to end by looking at the important role of universities, California universities, in fostering this human rights era for indigenous peoples in the United States. Then finally, I believe we'll have time for some questions and answers as well. So let me turn, if I may, to my first task here. And that is the UN Declaration on the Rights of Indigenous Peoples, the contents of this declaration, and this new human rights framework. And as I mentioned earlier, this truly is a historic time for indigenous rights here in the United States, because we can now see 2 legal frameworks for defining indigenous rights in the United States. The first framework is our current framework, that is the one called Federal Indian Law, which is the body of federal law that establishes our existing legal framework for defining Native American rights in the United States. That is the bundle of political, property, cultural, civil rights as Native peoples. This framework was derived in the early 1800s from the international law of colonialism by the Marshall Court. And it has 2 sides to this body of law. It's got a good side and a bad side. On the good side, federal Indian law has a lot of very good protective features. The notion that treaties are the supreme law of the land and have to be recognized and enforced. The doctrine of inherent tribal sovereignty. The protectorate relationship between the Native nations and the United States. These are all very protective features of this legal framework. And under these protective features, we've witnessed the rise of our modern Indian nations in the last 2 generations here in the United States. We've seen in many parts of the country a cultural renaissance. We've seen great economic advances by many of our Native nations all as a result of these protective features in federal Indian law. But then on the bad side of this legal framework, that is the dark side of federal Indian law, we see that it also contains many very clear anti-Indigenous features, nefarious legal doctrines of race, of racism, doctrines of discovery, doctrines of conquest, doctrines of plenary power, doctrines of unfettered guardianship, espoused by courts that brand Indians as inferior peoples, that are still the law today. These nefarious doctrines that come to us from the law of colonialism, that can be traced back, have been traced back by legal scholars all the way to medieval Europe, are legal doctrines in this current framework that hold Native people back, make us vulnerable, and keep us poor. So that's the first legal framework that we can see today. But now also out on the horizon, we can also clearly see this brand new human rights framework out on the horizon. And this framework comes to us from modern international human rights law as laid out in the UN Declaration on the Rights of Indigenous Peoples. It sits out there on the horizon and it remains to be implemented. And so now that we have a national project and a movement in place to actually begin implementing this declaration after the endorsement of it by the United States, we are witnessing the dawn of a new era, a human right era. And I think that once this human right era and the human right principle is injected into the legal framework for Native people, our old framework of federal Indian law will never be the same. And so today, our nation stands at the crossroads between these two legal frameworks. And the challenge of the hour, I think, as a longtime Indigenous rights advocate in our nation, is to save the best, most protective features from our old legal framework and synthesize them into a seamless, strengthened, more just body of law with these human right principles for the 21st century in a post-colonial world. And this challenge of synthesizing these two frameworks calls for a focused law reform movement in our nation, a law reform movement that uses strategic law development methods very similar to what NAACP Defense Fund used to overturn Plessy v. Ferguson in the historic case of Brown v. Board of Education, a 58-year struggle of law reform. So for all of these reasons, legal scholars today see this challenge that sits before us now and opportunity as a very rare juris generis or lawmaking moment in American legal history for Indigenous peoples in the United States. So let me turn to the major points of this UN Declaration. You can go to your computer if you haven't read it. and download the UN Declaration on the Rights of Indigenous Peoples. Read it for yourself. It has 48 articles in it. I've taught, you can teach an entire law school class on these 48 articles because, as I say, they're very comprehensive. But how was the, my first remarks about the Declaration is how it was made. It was a initiative that went through the United Nations Human Rights Framework. It was in the works for over 30 years. When indigenous peoples, for the first time in history, accessed the international arena and worked elbow to elbow with UN diplomats over a 30-year period in the making of this international instrument, going from stage to stage through the process until the General Assembly finally approved it. Now, this declaration is part of a larger body of international human rights law. That is, the UN treaties, the norms of nations that are found in customary international law. And so the document basically draws from this larger body of settled treaty principles and settled norms and puts them in this declaration as a guide to nations about how to acknowledge, recognize, and protect the fundamental human rights of indigenous peoples. This is a landmark document for a number of reasons. First of all, the Declaration really, for the first time, makes international law accountable to Native people or indigenous peoples. In the past, international law espoused the law of colonialism for hundreds of years. That was and had anti-indigenous functions in it that justified the settlement, colonization, subjugation of Native peoples around the world, making everything perfectly legal. This document is also landmark for another reason, is that it's really the first time that indigenous peoples have participated in making a standard-setting international document. So we can see in the Declaration the authentic aspirations of the world's indigenous peoples. So this Declaration then is a guide for all of the nations of the world to steer away their policies and law from the lingering ill effects of the legacy of colonialism and conquest. Article 43 of the Declaration states that the rights that are enumerated in this Declaration are rights that are recognized as the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world. Now, the status of this legal document, the legal status is that it's not a legally binding, self-enforcing treaty, but it's rather a declaration of norms and emerging norms that the UN hopes to encourage all nations, member nations, to comply with. And so in Article 39 of the Declaration, it asks that all nations implement all of these provisions in consultation with and in partnership with indigenous peoples. And as I say, this was approved by the General Assembly, the nations of the world, in 2007, was endorsed by the United States under the Obama administration in 2010. 150 nations around the world have also endorsed it, making the Declaration the new order of the day. The second thing that I'd like to mention here about the contents of the Declaration is that, importantly, in the preamble, it states that the rights that are laid out in this document are inherent rights of indigenous peoples. That is, inherent rights that are derived from indigenous institutions, governments, cultures, histories, spiritual traditions. What are human rights? I want to pause just a minute to talk a little bit about the fundamental nature of human rights, because this is what we're talking about here. We hear a lot about human rights on TV, and a lot of the human right discourse comes to us mainly from the United Nations and the international realm. And I know that our nation is willing to go to war to protect human rights, to punish those nations that violate human rights. And, you know, we deplore human right violations in other lands. But really, what are human rights? I think many, because we hear about them from the international realm, many might think that these are alien notions. But I think it's important to underscore that really human rights are homegrown concepts. They're as American as apple pie. And quite simply, I would define them as human rights as being the fundamental freedoms all human beings enjoy as a matter of right. And in international law, the content of particular human rights are elaborated on in modern international human rights law through the norms of customary international law and through the UN human rights treaty provisions agreed to by the nations of the world. And as I mentioned, these notions of human rights are not alien to America at all, because we here in this country have a very splendid human rights history, a very long, a very proud history that really defines our nation. The United States was in fact birthed by the human rights principle. Our founding fathers were gripped by the proposition that each person is endowed by certain inalienable rights that come to us from a higher source, the kinds of rights that all free and democratic nations were formed to protect, the kind of rights that no nation can take away. And many of our forefathers, described these as natural rights or the sacred rights of mankind. But they basically, the American Revolution arose because of the denial of human rights by England. And these rights and notions went on to animate our nation. The principles and precepts of human rights were on the lips of the people, our people, at every important juncture in American history during the growth and expansion of our democracy. And so we're very familiar with human rights, and they are homegrown precepts. The third thing I'd like to talk a bit about this declaration is as I mentioned earlier, the declaration establishes a comprehensive, standalone human right framework that literally addresses the full range of Native American issues and aspirations, authentic aspirations concerning Native American property, political, civil, environmental, economic, social, and cultural rights and relationships among indigenous peoples and the United States. So it's a very comprehensive body of framework in 46 articles. And at the heart of these rights is the human right of self-determination, which is a worldwide right of self-determination, the right to determine your people's own destiny. Every peoples around the world has this right as a matter of human law. So that's the core centerpiece of this declaration, and that's the indigenous right of self-determination and all of its corollary rights, which include these corollary rights that put flesh on and further define the meaning of self-determination. Includes the rights of self-government, the indigenous right of indigenous institutions, the human right of equality, the human right of life, integrity, and security, broad-based cultural rights, education rights, and rights with regard to accurate public media, political rights in the decision-making process with free, prior, and informed consent, economic and social rights, rights to lands and territories, natural resources, rights to have treaties and agreements with indigenous peoples recognized and enforced. So this is a lot of corollary rights to the fundamental right of self-determination that are addressed here. They're described as inherent human rights of indigenous peoples. And again, these are inalienable and indefeasible kinds of rights. And I think it's important that these are inherent rights, because it means that really the UN didn't give these rights to indigenous peoples. They already had them, but that they were simply out of reach or beyond reach, through the process of colonization and the settler states that carried out or continued these institutions of colonizations, many down to the present day here. These kinds of rights then were pooled from the larger body of existing international human rights laws I mentioned earlier. They're the kinds of inherent rights that the rest of humanity already takes for granted. And so they're not new rights or special rights for indigenous peoples, but rather the United Nations here just simply went to that larger body of international human rights law and applied it to the circumstances of indigenous peoples who live in colonized lands under the cloud of this legacy of conquest and colonization. And the purpose of the declaration is a remedial purpose, and that is to try to rectify the historical violations of these indigenous rights by colonies and former colonies, and help discard the remnants of these this unwanted legacy of colonization. And also importantly, about these rights is that they're supposed to be, according to the Declaration, interpreted according to notions of equity, equality, non-discrimination, justice, democracy, good faith. So we have a body of rights that come from a very just foundation, far more just than the kinds of rights that came from the law of colonialism with its bent towards dispossession and subjugation. The fourth major point I'd like to mention is that these UN standards are largely compatible with US law and policy in three major respects. First, they are compatible with our American core values. As I mentioned, our wonderful human rights legacy that we are all so proud of. These kinds of rights for anyone are consistent with these American core values. And it's true that we haven't always lived up to our ideals or our core values as a nation. But in each instance when we departed from these painful detours, these core values have always impelled our nation to self-correct, whether it be in the instance of slavery, segregation, lack of rights for women. We've always been impelled to self-correct, to extend and grow our democracy during our nation's nation-building process over the years. Secondly, these standards are also compatible with the United States Indian self-determination policy that was initially espoused by President Nixon in the year 1970. And so for the past 50 years, the Indian self-determination policy to encourage the development of tribal governments, to empower them to make decisions about their own destinies, has been the policy of our country, all three branches of our federal government for the past 50 years. And so the self-determination policy of this declaration is very compatible with our Indian self-determination policy. And then finally, these standards are also compatible with our legal culture here in the United States at its best and in its finest hour. If you look at the 10 best Indian law cases ever decided, whether it's on places of tribal holy places, repatriation, whatever the case might be, if you took the 10 best cases ever decided, see that they're compatible with these principles. Unfortunately, the 10 best cases have always been sort of fleeting victories that have been eroded over time. Standards. And so it just seems to me that the United States in 1970 embarked on this self-determination policy for Native America to improve our situation here in this country. And we have witnessed the rise of modern Indian nations over the past two generations. And this declaration will show us the path forward to finishing that process so that we can complete the final chapter of our nation building process to Declaration. As I mentioned, there are 46 articles in this declaration. It's a very comprehensive document. I invite you to go to your computers and download it, read it at your leisure. I've taught entire semesters about the contents of these. There's a lot of meat there. And if our nation were to implement this as intended by the UN, all of these articles, it will really change the way our nation looks at Native people and bring our legal culture up to its finest hour and make it more steady and reliable. Set of protections for the most vulnerable among us, and that is our American Indians, Alaska Natives, and Native Hawaiians. So read it at your leisure, and I will turn at this point to my third task here, and that is to address the need for implementing these standards here in the United States. As I mentioned, it's not a self-enforcing treaty that's binding on our courts, but rather it calls upon the United States, after it has endorsed this declaration, to sit down with Native people and develop a plan, a partnership for implementing the provisions into our law and policy. But I think it'll take a generation of work, of advocacy, to fully implement all of these provisions into our law. And so I think the threshold question for most Americans of goodwill is, why do we need these UN standards in the United States? Aren't we already the leading democracy in the world? Are you saying that we have injustice in our midst? Are we responsible for healing a painful past? That is, are we today supposed to pay for the sins of our grandparents? Others will wonder, well, isn't international law ineffective or unenforceable? Many don't like the UN. I know here in Oklahoma, we don't want to be bossed around by the UN, So why do we need these standards? Why can't we just use our existing law and policy to solve any problems with our indigenous people? So we have a Bill of Rights. Why not just treat everyone alike under the Bill of Rights? Don't we already have federal Indian law, a comprehensive legal framework already for defining Native rights in our country? So these are questions that all people of goodwill would have on their mind, and they're going to have to be answered, and I'm going to take a stab at it today. I think there are four very compelling reasons that speak to the need, or present a powerful case for the need to implement these human rights standards into our law and policy. The first are legal reasons. And here, legal scholars are well aware of the self-evident need to reform the dark side of federal Indian law. That is, those parts of the law of colonialism with anti-indigenous functions, such as the doctrine of discovery, doctrines of conquest, doctrines of racism, doctrines of dispossession, doctrines of subjugation, that were espoused by the Supreme Court in cases that have never been reversed. They're still the law of the land today, still relied upon to decide modern day cases. And so the legal scholars that have looked at this dark side of federal Indian law agree that we need to root out manifest injustice from this body of federal Indian law. There's also an internal tension within this body of law between the protective features and the anti-indigenous features. They're at war with one another, and that internal tension needs to be ironed out and resolved. And our scholars also tell us that we need to find some way to redress what is basically an amoral body of law. This body of federal Indian law is amoral because the Marshall Court back in the 1830s that was laying out the foundational principles for federal Indian law said we can't look to abstract notions of justice when defining indigenous rights. We can't engage in debates over morality. We just simply have to look at the law and apply it, which in that instance was the international law of colonialism. And so throughout that century, the Supreme Court insisted that justice and morality have no place in this body of law. And it's produced a very kind of a strange, amoral body of law governing Native people that has a very high tolerance for manifest injustice and manifestly miscarriages of justice that populate that body of law. And we can see that today in the erosion of Native American rights by our Supreme Court. Since the late 1980s, our Native nations have lost over 80% of their cases that go before the High Court. And so that means that prison inmates fare better, before the Supreme Court than our Native people do. So I think that there is a need for legal reform to replace the dark side of federal Indian law with these human rights principles, and that would produce a stronger, a more reliable, and more just body of law that really gives effect to the best in our legal culture. Then in addition, there's another legal reason as well, and that is if you do a comparative legal analysis to compare the body of federal Indian law with this UN human rights framework, you will see that there are many parts of our domestic federal Indian law that fail to comply with these minimum human rights standards. Just fail to meet these standards. For example, the self-determination principle under federal Indian law is not seen as a fundamental right or an inalienable, indefeasible right. Rather, it can be abolished by the government. And so what kind of a right is that? And here in Oklahoma, I'm going to give you a quick example. As president of the Pawnee Nation, we're confronted with a midnight rider that Senator Inhofe from Oklahoma, one of the dinosaurs in the Senate, has been in the U.S. Senate maybe 100 years, I don't know, tiptoed into the Senate chambers at one midnight under the cover of darkness in the year 2007, or 2000, yeah, about 2007, and tacked on a tiny little rider to a huge 800-page transportation bill that says, notwithstanding any other law, the EPA shall grant Oklahoma's request to exercise state jurisdiction in Indian country throughout the state of Oklahoma for environmental programs, if the governor writes a letter to EPA. And so that's exactly what Governor Stitt did last summer in response to this Supreme Court decision, the McGirt decision that held that the Creek Nation reservation was never diminished in size. So Stitt wrote that letter on behalf of Oklahoma, and EPA worked nights and weekends to grant that request, denying any legal protections at all for the 39 tribes of Oklahoma, and then justified that by that language and saying, well, that's the plenary power of Congress. And so you can see how easily, so now the state is intruding upon the sovereignty of 39 Native nations here in Oklahoma as we sit here tonight. Self-determination then can be abolished by the whim of one senator in this instance. And it just shows you how vulnerable our current right of self-determination is. Same way with our rights of equality and non-discrimination are beyond reach when judicial notions of race and racism are alive and well in federal Indian law. We see loopholes in our cultural rights. You can't get any legal protection for tribal worship at holy places located on federal land under the First Amendment. There's no federal protection for intellectual property rights. The Native American church use of peyote is not protected by the First Amendment. Our language rights protections are ineffectual. Public media is unaccountable to Native America. This free, prior, and informed consent standard of the UN is beyond reach by our government-to-government consultation rights. It's a much watered-down version. There's big socioeconomic gaps between Native America and mainstream America in housing, life expectancy, health, income, so on and so forth. Our land rights need to be strengthened. Our treaties, again, I'm going to give, have been abrogated in the U.S. Pursuant to, again, the plenary power of Congress. This midnight rider in Oklahoma, according to EPA, wiped out all of the treaties of the 39 Indian nations. Pawnee Nation has 8 or 9 treaties in place. With the stroke of a pen, all of them were abrogated with regard to, according to the EPA, by this midnight rider. Also protection, environmental protection for our indigenous habitats is very scant and unreliable as well. Some of the most awesome habitats in North America, some of the last best places in the United States are important indigenous habitats that gave rise to our native peoples and their cosmologies. So we have legal reasons here in the United States to embrace these and implement these human rights provisions. Secondly, there are social reasons for that speak to the need to implement the Declaration. We have in our country here in the United States an inherited legacy of colonialism that's left deep imprints and unhealed wounds in our American society that cry out for healing and reconciliation. This is all seen through the lens of historical trauma found in our tribal communities. It's seen in our legal culture, this legacy of colonialism, where the dark side of federal Indian law is alive and well, where there's a high tolerance for unjust cases. It's seen in these hard to solve social ills that are found in tribal communities, these shocking economic and socio-medical gaps that are root problems that are really the end product of this legacy of colonialism. So we have these social reasons to undertake a human rights framework here. And this UN declaration is the antidote for this legacy of conquest that shows us a path for reconciliation, for restorative justice, needed to heal our nation from a painful past, and then to move forward as a more stronger, united nation. Third, we have these political reasons to implement this declaration, because the UN pathway here solves a very perplexing political Indian question here. And that is, how do you incorporate Native Americans into the body politic and mainstream society after colonialism has run its course? Historically, our country has tried a lot of ways to incorporate Native people into our republic. It's tried the Worcester v. Georgia framework of domestic dependent nations. It's tried removal as an approach. It tried warfare and the use of force for a 100-year Indian War. It's tried the reservation approach. It's tried the rule of guardianship approach with forced assimilation. It tried the self-government approach from 1934 to the 1950. It tried the termination approach in the 1950s and 60s. And now it's on this self-determination course. But it's quite simple that the normal mode of incorporating immigrants into our body politic just doesn't work for Indigenous people who were already here before the nation was formed. So this UN declaration would bring Indigenous peoples into the body politic the right way, with the full measure of their inherent rights intact. And then finally, there are environmental reasons for embracing the declaration, because there's a congruency between protecting and recognizing Indigenous human rights and in protecting our environment as a healthy byproduct. Because if we protect the cultures and cosmologies of our native people and their indigenous habitats that have given birth to these cosmologies and our native value systems, that will provide the ingredients, a sorely needed ingredients for creating an American land ethic, a land ethic that is sorely needed to solve this worldwide environmental crisis that threatens life as we know it. And so there's this congruency between recognizing and protecting Indigenous rights and building a sound American land and sea ethic. So I'm starting to draw to a close here, so I'm going to speed up here a bit, but I just wanted to briefly mention a case study, for example, on this repatriation issue that is faced by California colleges here. I don't have a lot of intimate details about this problem here in California, but the UC system seems to house hundreds, if not untold thousands, of Native American human remains. Some 40 years after the passage of the Native American Graves Protection and Repatriation Act, that mandates the repatriation of these remains. And at least 10 years after the Interior Department passed rules and regulations to repatriate culturally unidentifiable human remains back to the tribes as well, which were enacted in 2010. So in the Declaration, in Articles 11 and 12, it includes the right of repatriation as a human right. And Article 11 requires nations to provide effective mechanisms to provide redress for religious and cultural property taken from indigenous peoples without their free, prior and informed consent or in violation of their laws, cultures, and customs, traditions. Secondly, Article 12 says that states shall enable repatriation of ceremonial objects and human remains in their possession through fair, transparent, and effective mechanisms developed in conjunction with the indigenous peoples concerned. So these two articles do address repatriation, and I think they serve to underscore the University of California's system's duty to repatriate these human remains that are covered by both federal and state law through effective measures as a inherent human right. And as I say, I know that the Nagpra law, which I was involved in the making of, was passed 40 years ago. It's been on the books, folks, for 40 years. And so it's an inordinate amount of time to fully comply with that federal statute, in my opinion. I know that some of the archaeologists and physical anthropologists now assert that after all these decades and decades and decades of having these skeletal remains, they're now saying, we don't know who these people are. They're culturally unidentifiable. But we do have these culturally unidentifiable rules in place under Nagpra now that should very clearly govern their repatriation and the criteria for doing that. And so because of this 40-year delay in fully complying, it does raise a question, at least in my mind, that the UC policies that are in place don't provide an effective mechanism to repatriate these remains. Because for me, justice delayed for 40 years is justice denied, I think one could say. And apparently, this repatriation obligation under our domestic and state laws here are not viewed as fundamental human rights by the UC system, because if they were viewed through a human right lens, then one would expect a more speedy and effective mechanism to be put into place to properly repatriate these remains. So I see the clock on the wall is telling me it's time to go. I just wanted to end by talking just a little bit about implementing this UN declaration and discussing the role of the public university and the social good in that process. We stand at the face of a foot of the mountain today with these implementation challenges. I foresee the work of a generation on the part of all of Indian country, all of Native America, our tribal leaders, our tribal attorneys, our scholars, our activists, to mount the mother of all social justice law reform movements. And we will have to call upon all Americans of goodwill to help us along that way in a movement, social justice law reform movement that would employ strategic law development methods like the NAACP used for 58 years to win the Brown case in 1954. We need to have a national discourse, it seems to me, on human rights for Native America, a discourse our nation has never had. And we need to coax the government to develop a national plan to implement the Declaration in partnership and goodwill with Native America. In this regard, recently the Native American Rights Fund and the CU Law School in Boulder have formed a national project to implement the Declaration into U.S. law and policy. They're working closely with Angela Riley and the UCLA Law School, or the Native Nations Law and Policy Center in that regard, to develop, to enlist now tribal leaders to spearhead this movement, to begin with a tribal grassroots legislative movement to call upon our native nations to pass tribal laws endorsing the Declaration, calling on other jurisdictions to do the same across the nation. And the project is developing a tribal toolkit for tribal attorneys and tribal leaders to educate themselves about the Declaration. We have a precedent in the 2019 legislation that was passed by the British Columbia up in Canada that aligns the laws of British Columbia with the Declaration, that I think can provide a precedent for all of our Indian nations to pass these laws, a precedent for state legislatures to do the same thing, and a precedent for federal legislation here in the U.S. as well. So I hope that as we embark on this campaign to secure the passage of over 500 laws by our native nations, that we can also look to some low-hanging fruit in the state legislatures as well, and particularly here in California, to work with the California tribes and the California community and the California education systems to pass a law in California, just like British Columbia has done, which would create a very strong national precedent for our nation in this movement. And so that brings me to the end of my talk and the role of the university, the public university in this capacity. I think that California universities can play a vital role in this great American social movement through its programs and activities across the state. The university system, I think, should strive to foster the conditions for diversity, for goodwill, for equality throughout the state. These create the conditions needed to recognize indigenous rights. We can't have a climate of mistrust, ill will, hate, division, and racism. That has to be discarded, because that kind of a climate incubates the conditions for genocide and would be counterproductive to recognizing indigenous rights. Secondly, professors teach human rights, principles and precepts to your students. Identify barriers to achieving the full measure of human rights for Native people, teach the real American history, that is our legacy of colonialism and conquest, so that our next generation can confront our inner demons in American history that impugned our core values, so that this generation can face these inner demons and move forward with remedial justice. I think that the universities can do a lot of scholarship in the realm of human rights to research and write about, to create a body of literature for a movement of this nature. You can research and write about the philosophical underpinnings for such a movement and provide brain power for the movement, just like universities did for NAACP's stride towards equality under the law. Other ideas that come to mind are writing of policy papers or hosting roundtables or seminars with interdisciplinary approaches with stakeholders to sit down with Native people here in California and focus on what are human rights for Native people and how can they be accomplished. And to the law schools, I think we need to train a new breed of lawyers, human rights lawyers, that can be advocates in this kind of a movement. So with that, Professor, brings me to the end of my remarks, and I thank each and every one of you again for this wonderful, wonderful opportunity to be here at UC Davis. And again, it's been such an honor for me personally to appear here, to broadcast to you. And with that, I hope that the Great Spirit will be with each and every one of you in your endeavors in the days to come. Thank you.
Dr. Yao Yao, Walter, thank you so much for a wonderful presentation. I took lots of notes, even though I've read your books, and I'm, but I still, I appreciate the way that you offered your remarks today. I wanted to let you know that we did have an attendance today. Professor Keith Wattenpaugh, who is the director of the Human Rights Studies program here at Davis, noted in the chat that he had his 150 students from the UC Davis Human Rights Studies core course who joined us today. So I just want to thank him for that and acknowledge that he let us know that, and that they're all here with you. So. We also we're dividing up the question, the Q&A portion. Professor Middleton, Beth Rose Middleton, who is the chair of Native American Studies, will be sharing the posing of questions to you. So she's going to take the first question to offer you.
As long as they're easy ones.
I promise that. Thank you so much for that wonderful lecture. And we have some terrific questions, so thank you to audience members who submitted questions. We'd like to start with Melvin John Ashu, who asked if non-federally recognized Native nations have any protections through the UN Declaration on the Rights of Indigenous Peoples.
Yes, I think they you can make a very strong case that they do. The declaration itself does not have a definition of Native nations. It allows, in fact, I think there's an article there that allows nations to define their own membership. And so I believe that the federally recognized distinction that we draw here in the United States for purposes of our domestic law would not prohibit the recognition and treatment of any indigenous peoples. And I think, nor are indigenous peoples defined either by this declaration, but in general international law parlance, there's no black and white definition, but I think the most common definition of indigenous peoples are the native people that resided in lands colonized by Europeans that were there before the Europeans and self-identify as native people, And so I think that you could make an argument for that. There are other situations such as Native Hawaiians that don't have a real firm recognition of the nature of their sovereignty either, that would have a blank sheet that they could craft their own self-determination and their own sovereignty based on these human rights framework here, and have a stronger, more just framework for their sovereignty than we have on the mainland here, for example. Similarly, up in the state of Maine and up in Alaska, I think that this human rights framework is probably superior than the statutory framework that they have received, which left them with sort of a watered down kind of a framework of sovereignty.
Thank you. I guess I'll take the next question. This question is from Jess Boone. He says, first of all, I would like to thank Walter Echohawk for sharing his work with us today. Oh my goodness, the question moved. Okay. Here it is. My name is Jess Boone, and I'm a 30-year-old child and youth care worker from Vancouver, British Columbia. I've been working with children and youth from care for the last 10 years, many of which are Indigenous children and youth. For my question, you mentioned that implementing UNDRIP would take a whole generation. What are some of the ways those working on UNDRIP can involve and engage Indigenous youth in this complex work who are most often impacted by these issues?
Well, I think the declaration, first of all, it addresses youth and women and elderly and disabled. As I say, it's a very, very comprehensive and very inclusive document that addresses the needs of the Indigenous peoples from the youngest to the oldest, and there is a place for youth in this campaign. As I mentioned, it's going to take all of Native America to demand these rights and wrest them away and fight for them. Just like up at Standing Rock, where we had a youth-based encampment of 10,000 people in the cold of winter that had a spiritual camp erected there, conducting ceremonies and songs and prayers, trying to protect the water of the Missouri River from pollution. And so it was a wake-up call for the Plains Indians in our part of the country. And I was very, very proud of our young people for doing that for about a year. And it makes me feel like our future is in good hands, that our younger generation learned well from their elders, and were able to do something like that inspired the rest of Native America and the nation at large as well, I think. And so in this movement, I think there's plenty of room, for that kind of advocacy by all Native people, including our young people. And hopefully along the way, they'll give us the inspiration, and they'll give us the backbone just like the young AIM leaders, I think, did in the early 70s. You know, they weren't, they were spring chickens back then, you could say. And so, no, there's ample room for that. What specifically it will be, I cannot say, but there is going to definitely be room for them in this.
Okay, thank you. Professor Middleton.
Yes, we have a question from Miranda Huron. What are solutions to professors who have taken intellectual property from Indigenous populations and willed it to post-secondary institutions, sometimes prohibiting access expressly to the nations? And this person notes that there are a few examples of this with respect to language. Are you familiar with that sort of context and what can be done about it?
I'm a little bit out of my expertise on intellectual property rights. I know that there are some international law work being done on intellectual property rights. I do know that our domestic legal framework for protecting intellectual property is inadequate to meet traditional native or indigenous needs, which are to protect our songs and our stories and other communally owned intellectual property. The statutes are not designed or set up to give that hardly any protection at all. It's all very, very scant. But if you look at intellectual property, and they're included in this document as well as an inherent human right, it would basically say to our nation that the intellectual property rights of indigenous peoples must be recognized as an inherent human right and protected as such in our system of laws, you know. And so it would make a space, I think, for protecting them as a human rights matter. And so as to what that would look like, that's going to be up to this younger generation of lawyers to hammer that out and translate that into possibly a form of a statutory recognition of these human rights to indigenous intellectual property.
Okay, another question from Cheryl Lightfoot, who is writing from the University of British Columbia. She says, here at the University of British Columbia, where I am senior advisor on Indigenous affairs, I have led and recently launched our university's Indigenous Strategic Plan, which aims to implement the UN Declaration within the university context. Do you see that universities in the United States might be prepared to move forward with similar plans as a contribution to the law reform movement?
I would certainly hope so, and I think that your program up there in British Columbia could be a model, could very well be a model, you know. And so I hope that you'll go to the send the Professor Inez here a copy of what you're doing up there, and also if you would be so kind to post that information or contact the NARF and the CU National Project. They have created a website. Gosh, I don't know. Inez, do you have that website address? They could possibly post what you're doing there in the university as a model that conceivably could be used here in the United States for doing the same thing. And, you know, hopefully that was a thrust of my remarks, is to encourage the UC system, which is one of the leading systems in our nation, to undertake a very robust set of activities here to help us enter this human rights realm in our nation. And so there is a place for universities, and I think that many of our leading universities would be places that would want to do this, you know. So I think if you got a model, I'm all eyes and I'm all ears. Thank you.
We have a question from an anonymous attendee. How can the average layperson contribute to supporting Native people in securing national and international rights?
I think that there is as I mentioned earlier, there's a place for everyone. If you're able, send some dollars into this national project because justice costs money. I hate to say it, but justice costs money in our nation. I'm very, very grateful that we've now found our champions in the Native American Rights Fund and at the CU Law Program. Just like Thurgood Marshall arose as the champion for NAACP, Legal Defense Fund. He argued and won 32 cases, more than any other person in the U.S. Supreme Court. He was involved as the champion of that cause. And we need lawyers and leaders of a certain kind in this effort. And I think that doing what you can as an individual to support this national project, because those are our leaders and champions at the present time. The Native American Rights Fund in Boulder, Colorado. Sue Noe is, I think, one of the leaders in that project. At the CU School of Law is Kristen Carpenter, who also has a position with the United Nations. Contact them, ask them, volunteer your help in some way, so you can contribute money and you can volunteer for different activities along the way, so it's going to take everybody, and everyone has a place and a role to play.
I see another question here from Professor Natalia Deep Sosa. You may have addressed this in your presentation, but what advice would you give to university administration and museums that are trying to reconcile, quote, competing rights of self-determination by Native Americans and other ethnic or racial groups?
Well, I'm not sure I understand the question by competing rights. I know that the rights that are being talked about here are inherent human rights, and under the Declaration, they're not meant to be disparaging of any other kinds of rights. They're not meant to tear apart the sovereignty of any nation. They're not meant to impinge upon the rights of anyone else. So I really don't see these kinds of rights that are laid out in the Declaration as really competing rights or contrary rights to any other group of people, because what we're talking about here at the end of the day, at the beginning of the day and at the end of the day, are worldwide, universally recognized human rights of the human race that are laid out in the UN Charter, that are laid out in a long line of UN treaties, that are laid out in customary international law, that are laid out in the Organization of American States intertribal court system as well. And so I don't know. I don't know that they're competing with anyone.
Thank you for that. Appreciate it. Inez?
So this is from Juan Avila Hernandez. Welcome, Walter. Oops, sorry, it moved. Welcome, Walter, and thank you for your awesome and inspiring presentation. Under your proposal of a new synthesis of the good portion of federal Indian law and a human rights model under UNDRIP, how do you see the call for the return of stolen lands in California playing out? Specifically here in California, with the unratified treaty lands initiated in 1851 to 1853 be returned or reestablished to California Indian nations and could they concurrently hold the lands they already possess under federal Indian law? I really love your statesmanship and the image of we step at the foot of the mountain. Peace.
Thank you for that question. Gosh, I haven't really studied out the facts of that issue to the point where I could render a legal opinion, other than to say that that there are a number of provisions in the Declaration that talk about the rights to lands, territories, and natural resources, and to protect those property rights. Of course, the right to hold property is a universal human right. And there are also, about a dozen cases in the Organization of American States International Court system dealing with the content of those rights and what they mean. So you would have another toolkit, I think, in terms of asserting, your rights. And again, I'm not familiar enough with the facts to tell you exactly how that would fit in, other than to say you would have if these kinds of rights were the law of the land, then you would have another set of arrows in your quiver, I guess, that you could utilize to protect not only your lands, but the habitats, indigenous habitats as well, environmental integrity.
Professor Middleton?
Thank you for that, both the question and answer. We hope in the future to host a panel of California tribal leaders focusing on the UN Declaration and on your work on the Declaration as well. I see a question here from Tracy Thomas, and she writes, if you were to write a sequel to your book from 2010, In the Courts of the Conqueror, the 10 Worst Indian Law Cases Ever Decided, what would be the top cases you are most concerned with today?
First of all, I don't know if I would write a sequel. I don't know if I have another book in me. I did in my current book, the book that I wrote, In the Light of Justice, which was kind of a follow-on book to Courts of the Conqueror, because I wrote the Courts of Conqueror. It came out in 2010, before the United States actually endorsed the Declaration. And when that happened, I thought, gee, I need to write another book here that analyzes the Declaration in more detail. Because I did reference it in the Courts of the Conqueror, but it was only a draft declaration back then, or it hadn't been endorsed by the United States, I should say. So I don't know that my cases would change. My methodology on picking the 10 worst cases, I was going to utilize some kind of an elaborate survey among my colleagues or whatever, And then finally I just said, oh, heck, I'll pick them myself. And I picked 10 cases that had very nefarious outcomes, manifestly unjust outcomes that I thought would be good examples. One could pick 20 cases or 50 cases, and maybe they wouldn't be the same 10 that I picked, but I think I would probably pretty much stick with those cases. There haven't been a lot of cases in the last 10 years that really jumped to my mind that I would add to it. I would say, though, in the light of justice, I have part of a chapter that talks about the 10 best cases and ever decided. And so you might be interested in taking a look at that at some point. Thank you.
We have a question from an anonymous attendee. Thank you, President Echohawk, for your presentation today. Do you think the UNDRIP is inherently in conflict with corporate capitalism? Can UNDRIP be successfully implemented without also ending corporate capitalism as we know it?
I think it could be utilized as a human rights check on unchecked corporate capitalism, however that might be defined, but the excesses of corporations and greed, I guess you could say, would be, there might be some checks, but I'm not exactly sure how you would define corporate capitalism. Possibly, I guess you're alluding to the excesses of corporations abroad and here in our own country too. To the extent that they are, those excesses are federal undertakings or state undertakings, either through licenses or permits or funding, then there would be a human right set of protections that could put those into the excesses in check when they trample on inalienable and indefeasible human rights.
We have a faculty member in Native American Studies who teaches a course on corporate colonialism. So I thought of that when this question came up, but thank you for your response. Professor Middleton?
Yes, we have a question from Brittany Arona, who's a PhD candidate in Native American Studies. She says, if human rights should be embedded into U.S. federal government law and policy, how does this coincide or clash with current calls toward decolonization in Indigenous nations?
It would coincide with it. Thanks for that question, Brittany. But the very purpose of this declaration, it's a remedial purpose, and that is to discard and rid the lingering effects of colonization from domestic political and legal systems. That's the purpose, and then to replace those lingering ill effects with the human right principles. So it is definitely a decolonization document that provides remedial justice, and it's also considered by international law experts as a nation-building process. In other words, it's part of nation building to expand the growth of the nation to include indigenous peoples into the body politic with the full measure of their indigenous rights intact. And in many respects, including in the United States, that's probably the last chapter of the nation building process of modern nations, and that is to bring native people who had been colonized and conquered into the body politic on a just, mutually agreeable basis, with all of their aspirations being protected, to create the space for them to exist within the nation as indigenous peoples with the full measure of their rights intact. So to that extent, it would be a very significant decolonization process that is entailed here. But so I don't know if that answers your question, but.
Thank you. Thank you. I think we're going to do one more question because we have a wonderful close to this event that I want to make sure we have time for. So this, and I apologize to the people who ask questions and that we're not going to address, but I can share all of those questions with Walter Echohawk at the end in an email. I will send him those questions. This one is from Megan Noble, who is our Nagpra program manager on the campus. Thank you, President Echohawk, for your talk today. As you mentioned, Nagpra was enacted long ago, and the UC and many institutions have considerable work to repatriate still in front of them. 30 years ago, Nagpra was advocated for and negotiated with a different legal and cultural landscape. Now that we have the benefit of UNDRIP and a stronger human rights framework, are there any changes you would recommend or like to see made if Nagpra was amended?
Well, I think NAGPRA is one of the few laws. Well, let me just back up a little bit. There's the federal Indian law and policy framework is almost entirely bereft of the human right principle. As I mentioned earlier, when the Supreme Court was defining federal Indian law, John Marshall said we can't look to abstract notions of justice or get engaged in debates over morality. And that's the way it's been. If you read all of the cases ever decided, four corners of each opinion, you won't find one judicial precept on human rights or one human right principle espoused in any of these cases that I can think of. So it's entirely bereft of the human right principle. Now, the Nagpra statute is one of the very few that actually is a human rights statute. And the late Senator Daniel Inouye stated that on the floor of the Senate when this legislation was on the floor of the Senate. He said, this is a human rights legislation. So that is the roots and the of NAGPRA. It's a human right law, and I was involved in the negotiations between that were hosted at the Barry Goldwater Center in Arizona between Native and anthropology and archaeologists and museum leaders. And we were at an impasse in those negotiations trying to figure out this legislation because each of the interest groups had their own self-interest at stake. And what broke that impasse was the human rights principle. And we said, let the human rights principle guide us to finding a way forward on this legislation because nobody wants to tread on human rights. And that kind of broke the log jam, and we were able to put things together. And then it breezed through Congress, and on the floor, Daniel Inouye said, this is a human right law. And it's one of the only pieces, one of the few pieces that I'm aware of that is a human rights law. So I don't know that I would, no law is perfect, and but I don't know that I've got any major amendments or that I have in mind that I would make, other than if that law I think needs to be viewed through the lens of human rights, because the UN Declaration also has human right repatriation provisions, and it makes it very plain to the entire world that repatriation is not a favor, it's not an entitlement or a privilege, it's a human right obligation. And so I think that just sort of informs and reinforces the duty of any institution that holds objects subject to repatriation to create an effective mechanism for repatriating those remains. An effective mechanism means it has to be created in consultation with Native people concerned, and it's got to be promptly executed. It can't be a 40-year or 50-year provision. That's part of the reason why Congress passed NAGPRA, because it took 40 or 50 years to try to get these items repatriated, and that was not deemed acceptable by Congress. They felt they had to get a law passed to speed up the process. So I don't have any amendments to elaborate, I guess, but that would be my take on the Nagpra law.
So thank you so much for everything, and for being here. We have a thank you from many people in chat, and I'm really happy that you were able to be here with us. And we asked a very special person to offer an honor song for you at this moment. He is John Carlos Perea, who is an ethnomusicologist and associate professor of American Indian Studies in the College of Ethnic Studies at San Francisco State University. He's the author of Intertribal Native American Music in the United States, published by Oxford University Press in 2014, as well as other publications. He maintains an active career as a Grammy Award-winning multi-instrumentalist and recording artist in the San Francisco Bay Area. He's recorded on 18 albums as a sideman and 2 as a leader, First Dance in 2001 and Creation Story in 2014. His most recent creative work is Alcatraz Reflections 2019 for Native American flute, laptop, and small ensemble. In April 2019, Professor Perea was recognized by the San Francisco Arts Commission's American Indian Initiative for his musical contribution, quote, to reclaim space, to challenge false narratives, and to reimagine public art from the perspective of Indigenous peoples. So I can't think of a more wonderful way to honor you today, and thank you so much with all our hearts for being here with us and for the generosity of your time. And I also thank everyone who attended. I see we have many people still here, and some probably had to leave to go to class or other places, but I thank everyone who helped put this together, and everyone who is here still, and the ones who left. And I just ask for many blessings for you, President Bohawk, and wish you well with everything that you're doing.
Thank you.
Juan Carlos.
Thank you very much. I'm very happy.
Professor Perea, sorry.
That's okay. I'm very happy to have been invited by Inez to support the event and to offer a song to honor Walter Echohawk. I was taught to sing by Dr. Barney Honer from Wakpala, South Dakota, and this is one of the songs that he taught me that we still teach at San Francisco State in the American Indian music class. This song says, "I love the Indian ways. The ways of the people are dear to me." Yahweh, Yahweh,
Aste.
Oh, Kechi Yao Yao, John Carlos, Professor Perea. And Kechi Yao Yao to you, Walter Echohawk, and to everybody who was here. Thank you so much. And I guess we'll end here.
Thank you. Thank you, Inez. Appreciate it.
Okay.
You're the best.
You're the best. Okay, thank you. Bye. Bye. Goodbye, everyone.